In June of 2024, AccessiBe was sued, and then 3 weeks later, a similar complaint was filed against UserWay. I've covered the AccessiBe class action previously, but I have not covered the UserWay complaint, and that is because I did not know about it until a few days ago. So I've created a PowerPoint. The title is UserWay Class Action Lawsuit. On this next slide, I have the thumbnail from Colleen Gratzer's video titled UserWay Class Action Lawsuit. And that is because I think Colleen does a really nice job of summarizing some of the key takeaways from this complaint. So I will link to Colleen's video in the description, and her channel is Design Domination. The talking points for this presentation are: 1, what's going on; 2, we'll look at some language from the claim; 3, we'll look at some screenshots from overlayfactsheet.com and overlayfalseclaims.com, and then we will conclude with some notes. So what happened? UserWay, a popular overlay widget seller, was sued in a class action lawsuit. And again, this complaint was filed in July of 2024. And I just found out about it, but keep this in mind as we're going through the slides, that this complaint was filed several months ago. And here I have a screenshot from the complaint, and we can see that it was filed on July 19th, 2024. So on this next slide I have, it's not illegal to sell overlay widgets, but it is against the law to deceive consumers. And so that's really what's in controversy when it comes to this complaint. Was the website owner, Bloomsy in this case, was the website owner deceived by the marketing and messaging put forth by UserWay? And so now we can look at the exact language from the complaint. And so in paragraph 1, the first sentence reads, "Plaintiff brings this action seeking damages caused by UserWay's misleading and false representations." And then skipping down to paragraph 7, I have another screenshot, and it reads, "UserWay's claims about the efficacy of its products are overstated, and many of its specific representations are materially misleading and false, as is its guarantee that its product will ensure that a website is ADA compliant." And then skipping down the complaint, this paragraph also reads, "In many cases, installing UserWay's widget actually hinders accessibility." And then paragraph 8 reads, and I'm going to read the entire paragraph, not just my highlights. "UserWay advertises that its products will lower and even eliminate the possibility that customers will be sued for ADA violations. UserWay's claims in this regard are false. In fact, businesses that use UserWay's products are more likely to be the targets of lawsuits. Use of UserWay's widget serves as a signal that a business has used a flawed shortcut, one that impedes visually impaired people." And now we have a screenshot that is included in the complaint. So this screenshot, the heading here is frequently asked questions, and we have one frequently asked question visible, and the question is, does UserWay provide full ADA compliance? And the first line reads, "Yes, UserWay's AI-powered accessibility widget provides full ADA and WCAG 2.1 compliance." Now keep in mind with these screenshots is that they are from a point in time. So the screenshots that are in this PowerPoint and are in the complaint may not be what is displayed. The language may not be the same as what's displayed currently. So going back now to the language of the complaint from the screenshot, we have section C, which reads, "As of December 2023, UserWay amended its frequently asked question to state, yes, UserWay's solutions," and I have solutions highlighted because it's plural, "UserWay's solutions ensure ADA, WCAG 2.1 and 2.2 compliance through our AI-powered accessibility widget." And note here that WCAG it reads WAG, but obviously this is supposed to be WCAG. And then going back to the complaint language, the complaint reads, "This amended answer remains false." And then in section D, it reads, "UserWay's website currently represents that UserWay's accessibility widget will make websites, quote, conform to WCAG 2.1 and 2.2 and boost performance along the way. So on this next slide, we have another screenshot, but before the screenshot, we have paragraph 38, which reads, UserWay's claims that its customers can, quote, avoid lawsuits with only a single line of code, end quote. And then we have a screenshot, and this is from the UserWay website, and we're going to, I think this is from the homepage. And as I'm reading through the language here, what I want you to think about in your mind is, what would your takeaway from this be? Let's say that you are a website owner, you've heard about website accessibility lawsuits, you want to make sure that you're not sued. If you were to come across this heading in the bullet points below, what would your takeaway be? So here we have the heading, the #1 web accessibility solution for WCAG and ADA compliance. And then there are 3 bullet points. The first reads, get compliant and avoid lawsuits with only a single line of code. The second reads, the strongest legal mitigation with a $1 million guarantee. And the third bullet point reads, trusted by more than 1,421,130 websites, including, and we have the logos for eBay, Coca-Cola, Disney, FedEx, and the Tokyo 2020 Olympics. So now we're going to look at a few screenshots from overlayfactsheet.com. And so we'll go back to the complaint in a moment, but this first screenshot is just a snippet. And by the way, overlayfactsheet.com contains a lot of information, and I highly recommend you go through and read through some of it. But this one screenshot, or this one snippet reads, many users with disabilities have expressed strong words of dissatisfaction with overlay products. As shown below, overlays themselves may have accessibility problems significant enough for users to take steps to actively block overlays from appearing at all. And one part of overlayfactsheet.com is simply testimonials from users with disabilities who have encountered that have encountered overlays. And then we also have a section, and this here, the heading is statement from sponsors and signatories to this fact sheet. So as of the date this video was recorded, there are 942 people who have signed to the following 4 items that I'm about to list out. So I'm just going to list these. We'll go through these quickly, and then I'll continue on with the signatures. So as a result of the above information, so referencing all of the information that's contained on overlayfactsheet.com, 1, we will never advocate, recommend, or integrate an overlay which deceptively markets itself as providing automated compliance with laws or standards. 2, we will always advocate for the remediation of accessibility issues at the source of the original error. 3, we will refuse to stay silent when overlay vendors use deception to market their products. 4, more specifically, we hereby advocate for the removal of web accessibility overlay and encourage the site owners who've implemented these products to use more robust, independent, and permanent strategies to making their sites more accessible. And then I have another snippet which reads, in short, the list of signatories below are people who are experts in this field and have dedicated their professional careers to the improvement of accessibility or are end users with disabilities or both. Discounting the names listed below as quote-unquote competitors is both inaccurate and misses the point. Overlays are not an effective means of ensuring accessibility, a point of which all of the people below agree. And again, there are 942 people who have signed overlay fact sheet. And so just reading through the names that we have here on this snippet, I have 5 names. We have Carl Groves, founder and president, Tenon.io, and Carl has put in a lot of work, including with overlayfactsheet.com, into providing the correct information on overlays. We have number 2, Matt King, chair, W3C, ARIA Authoring Practices Task Force, and W3C, ARIA and Assistive Technologies Community Group. 3, Bill Dingler, totally blind computer science student and code contributor to the NVDA screen reader, Swarthmore College, Philadelphia. 4, Nicholas Steenhout, independent accessibility consultant. 5, Ryan Redvert, I think that's how you pronounce that, web accessibility specialist. And the list goes on. And again, to date, there are 942 professionals or people concerned with accessibility that have signed this. Really, we'll call it a document. That have signed the document that is, or at least it's signed to this. What do we even call it? To this statement. That here lists out these 4 items that we will not advocate for overlay widgets. So this is the people that have signed this document are the experts among the experts, right? Carl Groves, Matt King, Bill Dingler. These people are, they are the most qualified to speak on accessibility. And if they are making this document, it is not a matter of competition or anything of this sort. They are speaking out against it because overlays do not provide for WCAG conformance. All right, and so Carl Groves also has a resource called overlayfalseclaims.com. And here we have the heading, Truth in Advertising Does Not Exist for Overlay Vendors. And then underneath that, it reads, false claims at the expense of customers and persons with disabilities. And we have this table of contents, and I've just highlighted number 2, false claims among web accessibility overlay vendors, and 3, specific examples of false claims made by overlay vendors. And I include, in fact, let's go through one more screenshot. Here we have Appendix A from overlayfalseclaims.com. So Appendix A, companies sued. And I believe if you can find this under the downloads link if you go to the navigation menu. But here it reads, the below is an incomplete list of lawsuits filed in U.S. district courts against companies which use overlay products. In each of the almost 200 cases listed below, the defendant's website was using the overlay widget listed in the 3rd column on the date that the lawsuit first appeared in Pacer. The filing of these lawsuits against overlay customers proves that the legal protection claimed by overlay vendors is not possible. And then here, the screenshot is cut off, but we have a list of 4. And what makes the cutoff is on number 4, the website owner had the UserWay widget installed. And then the first 3 website owners had EqualWeb, AccessiBe, and AccessiBe. And by the way, overlayfactsheet.com and overlayfalseclaims.com have been around for years. I don't even remember when they were initially published, but they've existed for years. And this list is extremely dated. There are many more complaints that have been filed. And me saying this is dated is nothing against the list. It takes a long time to compile this information. As it is, it tells you all you need to know, that websites, that overlays, even when installed on websites, are not preventing complaints from being filed. And on this next slide, we go back to the complaint. In paragraph 90, it reads, defendant failed to inform consumers that its products would not cause websites to meet WCAG success criteria. Defendant also failed to inform consumers of the volume of web accessibility lawsuits against UserWay subscribers. Defendant's failure to so inform consumers was and still is likely to deceive reasonable consumers. Keep that phrase in mind, because now we are going to look at the reasonable consumer standard. So I've taken a screenshot of an excerpt from an article on ecommerceattorney.io, and it looks like this is for the law firm of counsel, or the law firm Counsel Jones and Haley PC. I will link to the article in the description, but for now I've highlighted just 2 parts. First, we have reasonable consumer standard, and then we have this. For a plaintiff to prevail, the reasonable consumer standard requires a showing that creates a likelihood of deception or has the capacity to deceive reasonable consumers. And the reason why I include this is because if this case were to be litigated to where we are actually hearing arguments, then I think that is very likely the reasonable consumer standard would come up. So again, the reasonable consumer standard requires a showing that creates a likelihood of deception or has the capacity to deceive reasonable consumers. And so on this next slide, I have reasonable consumer standard versus marketing wordplay. So what the reasonable consumer standard does, it does many things, but one thing it does is it prevents the technically true but misleading impressions that can arise from clever wording and omissions. So I have an example here. So let's just imagine we have a multi-level marketing company and they are selling a health shake under the pretenses or the illusion that this shake causes you to lose weight. And so let's say that they are sued for deceptively marketing this shake. And the MLM company comes back and says, we didn't say that our shake was guaranteed to make you lose 10 pounds in a week. What we did say and what we did market is lose 10 pounds in a week, ? We guarantee you can do it. Try our new healthy shake. And so this is the type of wording and maneuvering that the reasonable consumer standard can help prevent. Because again, the reasonable consumer standard is going to look at whether the advertising, marketing, and messaging creates a likelihood of deception or has the capacity to deceive reasonable consumers. And so going back to this snippet from ecommerceattorney.io, does the reasonable consumer standard requires a showing that the advertising and messaging creates a likelihood of deception or has the capacity to deceive reasonable consumers. All right, so continuing on, we've talked about the language in the complaint. We've gone over overlay factsheet.com. We've also looked at some screenshots from overlayfalseclaims.com. Now, we can if there is no settlement and this case is litigated, UserWay will have the opportunity to present evidence to show that its claims were in fact true. So for example, that the UserWay widget does in fact result in WCAG 2.1 AA conformance. Also, if there is no settlement, UserWay also will be able to argue that even if limitations exist, that a reasonable consumer would not have been misled about their marketing claims and or that they provided adequate disclosure. And so here I have when we looked at the screenshot from the homepage of UserWay and we had the heading, the #1 web accessibility solution for WCAG and ADA compliance. Again, think of this in terms of this is when I don't know if this was the screenshot I asked you to think about this, but yes, it was. This is what we're thinking about. Would this create a likelihood of deception or have the capacity to deceive reasonable consumers? All right, and so now we are on the final part of this presentation, and we're going to we're in the notes section, and here we have a press release published on Business Wire, and here the title is Level Access Completes Acquisition of UserWay, Signaling the Next Evolution of Digital Accessibility. And this was published on March 20th, 2024. And so if you'll note that date, this is almost 4 months prior to the complaint against UserWay being filed. And here I've extracted a quote from the then CEO of Level Access, Tim Springer. And the quote reads, "Our vision for a comprehensive digital accessibility solution will empower organizations of all sizes and of all complexities to make faster progress and lasting impact, which equates to excellence for their end users. This acquisition sets the stage for a new wave of innovation, which will equip organizations to build accessible experiences at scale." So that was the then CEO of Level Access, and the CEO recently changed. But what's of note is that Tim Springer has published multiple articles that have been critical of overlay widgets. And so on the screen, I have one titled Lies, Damn Lies, Overlays, and Widgets. And this was published to LinkedIn. And here we have a section that now starts off the article. It reads, "Since the publication of this post, I have closely monitored the advancement of overlay technology capabilities. My position on these tools has evolved based on many factors, including the impact of artificial intelligence on automated remediation. My perspective is captured in our blog post, My Perspective, Digital Accessibility and Overlays." And so I have a screenshot from the My Perspective, Digital Accessibility and Overlays. This was published on December 31st, 2023. And it reads, I'll just go ahead and read this full paragraph. "Today, our company, Level Access, announced that we have entered a definitive agreement to acquire UserWay.org, a digital accessibility solution provider. UserWay is a public company and the transaction hasn't closed, so I can't discuss specifics about UserWay as a company, its products, or our agreement today. That noted, UserWay has been grouped with companies providing overlays." And I highlighted that last sentence, that noted, UserWay has been grouped with companies providing overlays, because I thought that to be an odd sentence to me, because UserWay has been notorious with that. And so it almost seems like Tim is saying that UserWay has been grouped by others and not himself. So I don't know, I can't tell from this sentence whether Tim includes UserWay himself in this group, or if it's just that there's this perception that UserWay is a company that provides overlays. But UserWay is notorious for its overlay widget. And we'd have to consult with Adrian Rosselli, but with UserWay, AccessiBe, and a few others, I'm sure, I think their genesis revolves solely around the overlay widget, and it's only over time where they have started to include more products and services that surround their overlay solution. And so the My Perspective, Digital and Accessibility and Overlays LinkedIn post was published on December 31st, 2023. And remember that this is prior to the acquisition actually completing, and that's what Tim Springer talks about at the beginning of this article. So another note, when you look at the complaint filed, I have here highlighted 4 different law firms: Urist Law Offices, PLLC, Stein and Nyparent, LLP, Law Offices of Ari Brown, PLLC, and then Heenan and Cook. And there's one other law firm listed, but of the 4 I started with, of the 4 I just mentioned, all 4 of those are named as the signing attorneys on the AccessiBe complaint. So that was also interesting. And then last, I want to end with a screenshot from Adrian Rosselli's blog post, #UserWay will get you sued. I believe this post comes after his other very the other post that he shared that is notorious is #AccessiBe will get you sued. Here, this was originally posted on September 13th, 2021, and he updated it on January 14th, 2025. Adrian Rosselli has put in, it has to be multiple hundreds of hours into documenting what has happened with overlay widgets and dispelling false notions that have existed and have been proliferated for so many years. So he's put in a lot of work. So I wanted to mention him at the conclusion of this video, but that's going to do it. I will include links to all of the references, all of the resources that I've mentioned, and all of the articles. I will link to those in the description.